Okay, let's unpack this. Have you ever found yourself wondering why two acts that look, well, pretty similar on the surface can lead to wildly different outcomes in court? Or how sometimes an act that seems clearly wrong might actually be deemed perfectly legal? Today, we're taking a deep dive into the fascinating, intricate world of circumstances affecting criminal liability.
Indeed. Our mission for this deep dive is to explore those, let's say, hidden gears and levers within the legal system. We're not just asking if a crime was committed, but how the law views that act and the true extent of someone's responsibility. We've pulled together some incredibly insightful sources to help you understand the nuances that shape the machinery of criminal justice. Think of it as getting a backstage pass, maybe, to the legal system, revealing how context is, well, everything.
Exactly. You're going to discover why some actions, while seemingly criminal, don't lead to punishment at all, or why others dramatically alter the severity of a sentence. It's about understanding the complex factors that can shift the entire outcome of a case. So let's peel back these layers and unravel these crucial circumstances one by one. First, let's get our bearings. Our sources lay out six main categories that influence criminal liability. Imagine them as different lenses, maybe, through which the law views an act, each one changing its legal perception.
That's a perfect analogy. These lenses are justifying, exempting, mitigating, aggravating, alternative circumstances, and absolutory causes. Each serves a distinct purpose, creating a kind of spectrum, from acts that are entirely excused, all the way to those that incur a much harsher penalty. It truly shows that justice isn't a simple yes or no, but a careful balance of why and to what extent.
Right. Let's kick things off with justifying circumstances. Here's where it gets really interesting, I think. These are situations where an act, though it might look like a felony and even cause harm, it's deemed totally fine by the law. It's like the law gives it a legal stamp of approval.
What's fascinating here is the core principle. The offender acted within the bounds of the law. This isn't about forgiveness, you see. It's about the act itself being lawful from the outset. Legally, no crime was committed, meaning no criminal liability, and, crucially as a rule, no civil liability either, because the act simply didn't transgress the law. It was okay to do it.
So if you're in court and raise one of these defenses, you're essentially saying, yes, I did the act, but it was justified under the law. It's an admission of the physical action, sure, but a powerful defense against criminal responsibility.
Precisely. And this triggers what's known as an inverted trial, which is quite something. In a typical trial, the prosecution has to prove guilt, right?
Right. Beyond reasonable doubt.
Exactly. But when a justifying circumstance is invoked, the burden shifts. It flips completely to the accused. They must prove, by clear and convincing evidence, the elements of their defense. If they fail, well, their admission stands and they'll be convicted.
Wow, so the stakes are really high when you claim justification.
Very high. It's a complete flip of the usual court dynamic.
Okay, diving deeper. One of the most well-known justifying circumstances is self-defense. We hear about this a lot, and it seems it's broader than just protecting your life, isn't it?
Oh yes, much broader.
It can cover your honor, chastity, even property if it's coupled with an attack on the person guarding it. The maxim here is stand your ground when in the right.
Absolutely. And the trick to a successful self-defense claim, legally speaking, lies in proving a perfect trifecta of elements. 1. Unlawful aggression. 2. Reasonable necessity of the means employed to prevent or repel it. And 3. Lack of sufficient provocation on your part. Missed just one of these, and the whole defense crumbles. It's quite strict.
Okay, so let's break that down. Unlawful aggression, that sounds critical.
It's the primordial element, as the sources put it. It's the absolute starting point. Without it, there's simply no need to defend. It must be a physical or material attack, actual or at least imminent. And crucially, unlawful. It can't be, say, a lawful arrest.
Actual or imminent, so a real physical attack happening or one that's just about to happen.
Correct. Actual means physical force, maybe a weapon. Imminent means it's on the verge of happening, a split second away. And it has to originate from the person you're defending against, the victim in the resulting case.
So it's not just a verbal threat or feeling scared. It needs to be a real, tangible danger, almost real anyway.
Correct. And then the second element, reasonable necessity of means. This doesn't demand perfect equality.
Yeah.
It's not like you have to use a spoon if they have a spoon.
Right, you don't need a sword to fight a sword if you don't have one.
Exactly. It's about what's rational, what's reasonable, given all the factors, like the nature and number of weapons involved, the physical condition, age, size of the people involved, even the place and time of the assault. Was it dark? Were you cornered? All that context matters hugely.
And the third element, lack of sufficient provocation. That basically means you didn't start it, right? You didn't egg them on.
Pretty much yes. Provocation is considered sufficient if it's adequate to stir a reasonable person to aggression, and it's proportionate to the gravity of the act committed. You can't claim self-defense if you provoke the fight unfairly.
Okay, let's look at that example from our sources. It makes it clearer. X is leaving an ATM. He gets ganged up on by A, B, and C. They beat him up. X pulls out an ice pick. Looks like he's about to stab X. X grabs the nearest thing. A stone hits A twice. A dies. X is prosecuted for A's death. Self-defense.
Yes, absolutely a textbook case, according to the analysis. First, unlawful aggression was clearly present. X's life was in actual imminent danger from that ice pick. Second, the means. Well, a stone against an ice pick with X unarmed and outnumbered. That seems entirely reasonable, necessary even. And third, provocation. X was just walking home. He gave no sufficient provocation. All three elements are there, so it should lead to acquittal. It perfectly illustrates the law's recognition of that fundamental right to defend oneself in a life-threatening situation.
Now, moving from defending yourself, what about defending someone close to you? That's defense of a relative, right?
Correct, and it shares the first two elements with self-defense. You still need that unlawful aggression against the relative, and the means you use to defend them must be reasonably necessary. But the third element is different and quite interesting. It's in case the provocation was given by the person attacked, that the one making defense had no part therein.
Ah, okay. So even if my relative, say, started the argument or provoked the attacker, I can still step in and defend them justifiably, as long as I wasn't involved in that initial provocation.
Exactly. Your justification stands separate from their initial actions, provided you weren't part of the problem yourself.
Now, who counts as a relative here? Is it just immediate family, or the sources seem quite specific?
They are very specific. It lists spouse, ascendants, like parents, grandparents, descendants, children, grandchildren, legitimate, natural, or adopted siblings, relatives by affinity, that's through marriage within the same degrees, like a father-in-law or mother-in-law, and relatives by consanguinity, blood relatives within the fourth civil degree. That includes up to first cousins.
That is specific. Why such a defined list, I wonder?
It likely reflects a legal judgment about the strength of bonds and the presumed instinct to protect those closest to us.
Yeah.
It draws a line, though.
Like the example given. X defends his 70-year-old father-in-law. The neighbor, W, punches the father-in-law and is about to stab him. X intervenes, punches WW, gets injured, ends up in the hospital. X is charged. Does defense of a relative apply?
Yes, it should. Let's check the elements. First, is the father-in-law a relative under the law?
Yeah.
Yes, an ascendant by affinity, same degree, covered. Second, was there unlawful aggression? Yes, the neighbor punched him and was about to stab him, clear danger. Third, was X's punch a reasonable means? Given the threat of stabbing, a punch seems reasonable to stop it. And finally, even if the father-in-law did provoke W somehow, the scenario implies X just arrived and had no part in it. So all elements seem met.
Okay, but here's a twist from the source. What if it wasn't his father-in-law, but his wife's first cousin being attacked by WX still punches W to save the cousin?
Ah, now that's different based on the list. A first cousin by affinity, related through his wife, doesn't fall within those enumerated degrees for X himself. So technically, defense of a relative wouldn't apply to X in that situation.
But surely he shouldn't just stand by.
No, and the law accounts for that. It would likely fall into the next category, defense of a stranger. Provided, of course, X wasn't motivated by some evil intent like revenge.
Ah, defense of a stranger. So stepping in for someone you don't even know or someone who doesn't fit that strict relative list.
Correct. Again, the first two elements are the same as self-defense and defense of a relative. You need unlawful aggression against the stranger. And the means you use must be reasonably necessary. The crucial third element here is different again. That the person defending be not induced by revenge, resentment, or any other evil motive. Your intention has to be purely altruistic, just to help.
Okay, the example here involves a student protest. Police are attacking students. Student W sees a policeman hitting another student, X, on the head with a truncheon. That's serious danger. W grabs an empty Coke bottle and hits the officer's forearm, just the forearm, to make him stop. W gets charged with direct assault. Is W liable?
According to the analysis, no. W is not liable if it's defense of a stranger. Unlawful aggression. Yes, the officer hitting X's head with a truncheon poses a grave, imminent danger. Reasonable means. Using an empty bottle on the forearm to stop a potentially lethal blow to the head seems proportionate and necessary. It wasn't excessive force. And the motive. The scenario suggests W simply intended to help a fellow student, not driven by revenge or malice against the police. So all elements align. It's a classic case of defense of a stranger.
Okay, let's move to the next justifying circumstance, state of necessity. This sounds like being caught between a rock and a hard place, forced into a tough spot.
It is, precisely. It refers to committing an act, which might otherwise be criminal, specifically to avoid greater harm or evil, either to yourself or to others. The person is exempted because their act, while potentially harmful in itself, prevents something far worse from happening. It's the lesser of two evils, essentially. The elements here are: 1, the evil sought to be avoided must actually exist. It can't be imaginary. 2, the injury feared must be objectively greater than the injury caused by the act done to avoid it. And 3, there must be no other practical or less harmful way of preventing that greater evil.
And crucially, the source adds, the accused must not be the one who created that state of necessity in the first place, right?
Exactly. You can't say, set a fire, then break into someone's house claiming necessity to escape the fire you started.
Right. So examples could be breaking into an empty house during a sudden, violent typhoon to seek shelter and avoid likely death. Or maybe swerving your car to avoid a head-on collision with a truck that crossed the line, even if that means hitting a parked car or, tragically, bystanders, because the alternative was certain death for you and potentially others. The harm caused is less than the harm avoided.
Those are good examples.
Yeah.
And then there's that fascinating case mentioned in our sources, the Hernandez case. She didn't show up for her own wedding. She was charged with serious slander by deed, basically causing public humiliation. But her defense was state of necessity. She argued she was avoiding the greater evil of a loveless marriage, an injury she feared would be far greater than the embarrassment caused by not appearing.
And the Supreme Court actually accepted that.
Wow. Yes, they appreciated it as a state of necessity. The evil of being trapped in a loveless marriage was considered real and substantial. The feared injury, a potential lifetime of unhappiness, was deemed greater than the temporary public embarrassment. And there was really no other practical, less harmful way for her to prevent entering that marriage at the very last moment other than not going through with it. She had the choice to contract or not contract marriage.
That's really something. But it raises a question. Does state of necessity, like the other justifying circumstances, mean zero civil liability too?
And that's where state of necessity stands out. It's
Yeah.
unique among the justifying circumstances. Our source clarifies that uniquely for state of necessity, there is civil liability, even though there's no criminal liability.
So you're not a criminal for breaking into that house during the storm, but you still have to pay for the broken window?
Exactly. You're not punished criminally, but the person whose property you damaged to save yourself is entitled to compensation. It balances the justification for your act with fairness to the person who suffered the consequences.
Okay, how about fulfillment of duty? This sounds like it applies mainly to people in authority, like police officers.
Often, yes, but it can apply to anyone performing a lawful duty or exercising a lawful right. This exempts a person from criminal liability if they commit an act that would otherwise be a felony, but it happens while they are properly performing their duties. The key conditions are: 1, the offender must have acted in the due performance of their duty or the lawful exercise of their right or office, and 2, the resulting felony was an unavoidable or necessary consequence of performing that duty correctly. It's not a blank check.
So it's not enough just to be on duty. The specific act that caused harm has to be a required and unavoidable part of doing that duty properly.
Precisely. For example, a police officer using necessary force, but not excessive force, during a lawful arrest that meets resistance. The rules on criminal procedure are clear. No unnecessary force or violence.
So the force is necessary and proportionate, that's covered. But what about the Degani case mentioned? Security officers charged with murder. They claimed lawful performance of duty.
Right, Degani and his co-accused were PNR security officers. They shot someone named Javier during what seems to have been a drinking spree. They argued they were performing their duty.
In the verdict.
No, the court rejected it.
Right.
The first element was missing entirely. They were off duty at the time of the incident. Being off duty means they were not acting in the due performance of their duties. So the defense failed right at the first hurdle. Foundational condition wasn't met.
Okay, and the last justifying circumstance. Obedience to a lawful order. This sounds like the classic, I was just following orders defense.
It is, but with very significant caveats. It's not a get-out-of-jail-free card for any order. This exempts you only if you commit an act in obedience to a lawful order issued by a superior. The elements are: 1, an order was actually issued by a superior. 2, that order itself must have been lawful. for a lawful purpose. And 3, the means used by the subordinate to carry out that lawful order must also have been lawful.
So if the order itself is illegal, obeying it provides no protection whatsoever.
Not at all. In order to, say, falsify documents or plant evidence is inherently unlawful. Obeying it makes you complicit, not exempt.
Yeah.
Or the example given, a soldier torturing someone to death, even if directly ordered by a sergeant. Torture is illegal. The order is unlawful. Obeying it is a crime.
So the order itself and the way you execute it both have to be legal.
Exactly. The principle is that a crime isn't committed if the mind of the person performing the act is innocent. But obeying an unlawful order doesn't create an innocent mind. You're expected to know the difference between a lawful and an unlawful command, generally.
Okay, that covers the justifying circumstances. Now let's shift gears to exempting circumstances. You mentioned earlier, unlike justifying ones where no crime is committed legally, here a wrong has indeed been committed. The act itself is unlawful. But, crucially, the offender isn't held criminally liable. How does that work?
It's a key distinction, absolutely. The underlying reason for exemption here is the absence of voluntariness in the commission of the act. Remember, for intentional felonies, voluntariness needs 3 things: criminal intent, malice, freedom of action, and intelligence, the capacity to understand. For culpable felonies, those based on negligence, it's criminal negligence, freedom of action, and intelligence. If any one of these essential elements of voluntariness is completely absent when the wrongful act is committed, the law exempts the offender from criminal liability.
But not necessarily civil liability.
Generally, no. Because a wrongful act did occur and caused harm, there's usually still civil liability to compensate the victim. The exemption is from criminal punishment, not necessarily financial responsibility.
So, similar to justifying circumstances, you're admitting the acts occurred. You might say, yes, I did that, but you're arguing against criminal responsibility because you lacked that essential voluntariness. You didn't freely and knowingly choose the wrongful act.
Precisely. You acknowledge the physical act, the actus reus, but deny the necessary mental state or freedom, the mens rea, or voluntariness.
Our sources highlight 2 types here under mental state: imbecility and insanity. What's the legal difference?
Okay, an insane person, in legal terms, is someone suffering from a complete deprivation of intelligence or reason at the time of the act. They cannot distinguish right from wrong, good from evil. It's a total mental aberration. An imbecile, on the other hand, is someone who, even though they might be chronologically an adult, has the mental development comparable to a child aged 2 to 7 years old. Their mental capacity is permanently stunted. Now, the critical difference for legal exemption. Insanity is not exempting if the wrongful act was committed during a lucid interval, a period when the person was temporarily sane and understood their actions.
So timing is everything with insanity.
Yes, but imbecility, because it's considered a permanent state without lucid intervals, is exempting under any and all circumstances.
And the law presumes everyone is sane, doesn't it? So the burden of proof must be quite high for the defense.
Extremely high. Sanity is the default presumption. The defense must prove insanity beyond reasonable doubt, specifically showing the accused was insane immediately prior to or at the very moment of committing the crime.
What if insanity develops after the crime?
That won't exempt them from liability for the crime already committed. However, their trial might be suspended, and they might be committed to an institution until their sanity is restored enough to understand the proceedings.
Let's talk about minority, the age of criminal responsibility. RA 9344, the Juvenile Justice and Welfare Act, changed things, didn't it?
It did, quite significantly. The rules are now quite clear under RA 9344. A child who is 15 years old or younger at the time of the offense is completely exempt from criminal liability. Period. No ifs, ands, or buts.
Okay, 15 or under, fully exempt. What about the slightly older teenagers?
For a child who is above 15 but under 18 years old at the time of the offense, exemption depends on whether they acted with or without discernment.
Discernment. That means understanding the difference between right and wrong and grasping the consequences of their actions right.
Exactly. If a minor in that age bracket, over 15, under 18, acted without discernment, they are exempt. If they acted with discernment, they are not exempt. But their minority will be treated as a mitigating circumstance, which we'll get to later.
And civil liability for minors, does exemption cover that too?
No, the exemption from criminal liability does not include exemption from civil liability. The minor, or usually their parents or guardians, can still be held financially responsible for the harm caused, unless the parents can prove they exercised reasonable supervision and took steps to prevent the offense.
Okay, what about accident? This sounds like it's just a complete mishap, no fault involved.
Yes, That's the idea. The legal definition is basically an unintended and unforeseen injurious occurrence. To qualify as an exempting accident, four elements must be met. One, the person is performing a lawful act. Two, they are performing it with due care. They're being reasonably careful. Three, they cause an injury to someone or something by mere accident. And four, there was no fault or intention on their part to cause the harm.
And what's unique about accident compared to other exempting circumstances?
This is a big one. Accident is the only exempting circumstance where there is neither criminal liability and/or civil liability. It's a total exoneration, financially too.
Ah, okay. Because if it was a pure accident with no fault, why should anyone be liable?
Hmm?
Makes sense. So the example of a careful driver going the speed limit, paying attention, who hits a pedestrian who suddenly darts out from behind a parked car without looking, that could be a legal accident.
Precisely, assuming the driver did everything reasonably possible. But contrast that with the firearm example. If someone borrows a loose firearm, meaning it's unregistered or illegally possessed, that's an unlawful act to begin with. So even if they accidentally shoot someone while, say, hunting or cleaning the gun, it cannot be claimed as an accident in the legal sense. Why? Because the first element, performing a lawful act, is missing. Their possession of the gun was illegal from the start.
The law looks at the whole picture, the legality of the underlying activity. Got it. This next one sounds intense. Irresistible force. Like being physically compelled to do something. A puppet on strings.
That's an excellent metaphor, yes. This exempts someone if they commit a crime because they were subjected to physical force so overwhelming, so irresistible, that it completely deprived them of their free will and voluntary action. Their own will is totally overpowered by the external force. The force must be, 1, physical in nature, 2, truly irresistible, something they genuinely could not fight against, and 3, it must come from a third person. You can't claim irresistible force from, say, a natural event. It essentially reduces the person to a mere instrument in the hands of another, with absolutely no freedom of choice left.
So maybe a bank teller forced by heavily armed robbers holding guns to their head to open the vault. They're physically compelled.
Correct. Or the example of someone forced at gunpoint to drive a getaway car. The threat is so immediate, so grave, and the force so direct that there's simply no room for voluntary action. They are acting under physical compulsion.
Okay, and how does uncontrollable fear differ from irresistible force? Is it more ecological?
You've hit on the key distinction, yes. While both result in the absence of freedom of action, irresistible force is about physical compulsion from outside. Uncontrollable fear, sometimes called duress, is about mental compulsion arising from an imminent threat. Here, the person acts wrongly because of an overwhelming, paralyzing fear of an evil that is equal to or greater than the harm they are forced to commit. They believe that not committing the act will result in that greater harm happening to them or someone else. The elements are 1, the existence of an uncontrollable fear. 2, the fear must be real and imminent, not some vague future threat. And 3, the injury feared must be greater than or at least equal to the injury caused by the act committed under duress.
The example in our sources really drives this home. It's quite dramatic. X witnesses 3 armed men, A, D, and C, with the victim Y, who is already injured and bleeding. A puts a gun right in X's mouth and says, "Shoot Y or I'll shoot you right now." X, absolutely terrified, shoots Y, and Y dies. Is X exempt due to uncontrollable fear?
Yes, based on those facts, X would likely be exempt. Let's check the elements. 1, uncontrollable fear. Being threatened with immediate death with a gun in your mouth certainly qualifies. The fear of death is primal and overwhelming. 2, real and imminent. Absolutely. The threat is happening right then and there. 3, feared injury greater than or equal to the act. The fear of being killed instantly is arguably greater than, or at least equal to, the act of killing another person under such extreme duress. All elements seem present. X acted without freedom due to overwhelming fear.
Okay, the last exempting circumstance is lawful or insuperable cause. What does insuperable mean here? Unbeatable.
Essentially, yes. Insuperable means a cause that could not be overcome by reasonable or ordinary means. It was beyond the person's control to prevent. This circumstance applies specifically when someone fails to perform an act that is legally required of them. They omit doing something the law commands. The exemption applies if their failure was due to circumstances genuinely beyond their control. The elements are 1, an act is required by law to be done. 2, the person fails to perform that required act. And 3, the failure is due to a lawful reason or an insuperable cause.
And interestingly, like accident, this one also exempts from both criminal and civil liability.
Correct. If you were legally prevented from doing what the law required, you're generally not held liable either criminally or civilly for that failure.
So examples might be a delivery driver contractually obligated to deliver a package by a certain time, but all roads are suddenly blocked by an unexpected massive landslide. They couldn't perform the required act due to an insuperable cause. Or maybe someone's summoned to appear in court as a witness, but they are suddenly hospitalized with a severe, debilitating illness on that day.
Exactly. Those are situations where you're prevented from complying with a legal duty by forces truly beyond your personal control. The law recognizes that you can't be faulted for such unavoidable failures.
All right, now let's move to mitigating circumstances. These are different again. They don't completely wipe out liability, like justifying or exempting circumstances, but they can significantly lower the penalty imposed. It sounds like there's still voluntariness here, but it's diminished, less culpable, like turning down the volume on the crime.
That's precisely it. A dimmer switch is a good analogy. There's a diminution, a lessening of the offender's voluntariness. This could be diminished criminal intent, reduced freedom of action, or impaired intelligence, but not a total absence like in exempting circumstances. Because voluntariness is only reduced, not eliminated, there's still criminal liability. But the law recognizes the lesser culpability by imposing a lower penalty.
Our sources mention two types, ordinary and privileged mitigating circumstances. What's the practical difference?
It's about their power. Ordinary mitigating circumstances can be canceled out or offset by any generic aggravating circumstances that might also be present. If they aren't offset, they generally reduce the penalty to the minimum period within the prescribed range. Privileged mitigating circumstances, however, are much stronger. They cannot be offset by aggravating circumstances. And crucially, they lower the penalty by 1 or even 2 full degrees on the legal scale, not just to the minimum period. They reflect a more significant reduction in the offender's blameworthiness.
Okay, so what qualifies? One interesting one is having an incomplete justifying or exempting circumstance. So you almost made the cut for full exoneration, but not quite.
Yes, exactly. The law acknowledges that you were partially acting under conditions that could have justified or exempted you. For example, let's go back to self-defense. Unlawful aggression is the essential element, remember. If only unlawful aggression is present, but the other two elements, reasonable means, lack of provocation, are missing, that incomplete self-defense acts as an ordinary mitigating circumstance. But if unlawful aggression plus one other element is present, for example, reasonable means but you provoked them, or no provocation but unreasonable means, then it becomes a privileged mitigating circumstance, leading to a 1 or 2 degree reduction in penalty.
So the more elements you satisfy, even if not all, the greater the mitigating effect.
Correct. It shows the law recognizes the effort or the partial justification, even if it was ultimately imperfect.
We touched on minority under exempting circumstances for those under 15 or over 15 without discernment, but it can also be mitigating.
Correct. If a child is over 15 but under 18 and acted with discernment, so they aren't exempt, their youth itself is considered. Their minority in this case becomes a privileged mitigating circumstance, automatically lowering the penalty by 1 degree. The law recognizes that even with discernment, teenagers may not have the full maturity and judgment of an adult.
And what about the other end of the age spectrum, seniority?
Yes, this applies to offenders who are over 70 years old at the time they commit the crime. Their advanced age is also considered a mitigating circumstance, potentially lowering the penalty. It acknowledges potential frailties or diminished capacity associated with old age. Usually ordinary, but can be privileged in some contexts.
Okay, now for that Latin term, praeter intentionem. It means beyond the intention, right? No intention to commit so grave a wrong.
Essentially, yes, that's a good translation. This applies when there's a very notable, clear disparity between the means the offender used and the actual result or felony that occurred. The injury caused was much worse than what the offender intended or could have reasonably foreseen for their actions.
Like, if you lightly punch someone, just intending to maybe bruise them or teach them a lesson, but unknown to you, they have an extremely rare medical condition, like an eggshell skull, and they die from that light blow.
That's a classic potential example. The means used, a light punch, were not reasonably calculated to cause death. The resulting death was disproportionate to the intent and the means. To determine this, the court looks at the weapon used, if any, the part of the body injured, the force applied, the manner of attack, all factors that shed light on the offender's probable intention versus the actual outcome.
Okay, these next three seem closely related, all involving strong emotions. Sufficient provocation, immediate vindication of a grave offense, and passion or obfuscation. How do we carefully distinguish them? They sound similar.
They do overlap in involving emotional states, but the triggers and timing are distinct. Let's break them down. Sufficient provocation requires a threat or act from the offended party, the victim of the crime, that was serious enough to provoke anger or loss of self-control in an ordinary person. Critically, this provocation must come directly from the victim and immediately precede the criminal act. There can be no significant time lapse for the offender to cool down. It has to be almost instantaneous reaction.
So, someone relentlessly insults your family right to your face using terrible language, and in the heat of that moment, you immediately punch them. That immediate reaction to their direct provocation could be sufficient provocation.
Precisely. Now, immediate vindication of a grave offense is slightly different. It also involves reacting to a wrong but. 1. The offense committed against the accused or their family, spouse, ascendants, descendants, siblings, must be grave, serious enough to cause intense indignation or pain. It doesn't have to be a crime itself, maybe a very serious insult or accusation. 2. Unlike provocation, it allows for a slight lapse of time between the grave offense and the reaction. Not immediate, but proximate, soon after discovering the offense.
So, finding out someone spread a vicious, false rumor about your spouse, feeling that deep sting, and then confronting and maybe striking that person shortly after hearing the news.
Yes, that fits the vindication idea better. There's a short interval, but the reaction is driven by the need to vindicate the grave offense. The focus is on the gravity of the offense suffered and the proximate reaction.
Okay, and the third one, passion or obfuscation. Obfuscation means confusion, clouding of judgment.
Exactly. This applies when the offender acts while their mind is clouded or obfuscated, by powerful emotions like intense anger, jealousy, or indignation. The key elements are: 1. There must be an act, usually unlawful, that is sufficient to produce such a passionate state. 2. The resulting crime must have been committed under the overwhelming influence of that passion, diminishing the offender's capacity for rational thought and self-control. 3. The act causing the passion cannot be too far removed in time from the crime. There needs to be a close connection. And importantly, the passion must arise from lawful sentiments. It can't be anger rooted in a desire to commit a crime anyway, or spurred by something trivial. It has to stem from a justifiable emotional response to a significant unlawful act.
Like the classic, albeit tragic, example of someone walking in on their spouse in the act of adultery and immediately reacting in a violent rage. The shock and betrayal cause uncontrollable passion.
Yes, that's often cited. The sudden unlawful act triggers overwhelming emotion that clouds judgment and leads to the crime. The core idea is the emotional turmoil impairing clear thinking and self-control.
So, to summarize the differences. Provocation is immediate reaction to the victim's act. Vindication is proximate reaction to a grave offense against oneself or family. Passion obfuscation is acting while overwhelmed by lawful emotion caused by an unlawful act, clouding judgment.
You've got it. They each have specific requirements regarding the source of the emotion, the gravity of the trigger, and the time interval between the trigger and the crime.
Okay, next pair. Voluntary surrender and voluntary plea of guilt. These seem pretty straightforward. The offender is cooperating after the fact.
They are relatively straightforward, yes,
Yep.
and they both reflect a reduced danger or criminality, meriting mitigation. For voluntary surrender, the elements are: 1. The offender has not actually been arrested yet. 2. They surrender themselves to a person in authority or their agent, like police. And 3. The surrender must be spontaneous and voluntary, showing a genuine intent to submit unconditionally to the authorities. It often implies repentance or acknowledgement of wrongdoing.
What if they only surrender after hearing a warrant is out for them? Is that still spontaneous?
It can be, yes, as long as they haven't actually been apprehended. The key is they took the initiative to turn themselves in before the law physically caught up with them.
And voluntary plea of guilt.
This requires: 1. A spontaneous confession of guilt by the accused. 2. It must be made in open court. 3. Before a competent court that will try the case. And 4. Critically, it must be made before the prosecution begins to present its evidence against the accused. A plea after seeing the strength of the prosecution's case doesn't count for mitigation.
Does it have to be a plea to the original charge?
Usually, yes. Pleading guilty to the specific crime charged in the information. Or it could be to a lesser offense if that's agreed upon through plea bargaining, as long as it happens before the prosecution presents evidence for the original charge.
Okay, what about physical conditions? Physical defect and illness. How can they mitigate liability?
Right. Physical defect refers to conditions like being deaf, dumb, blind, or having other significant physical limitations. This defect is mitigating only if it specifically restricted the offender's means of action, defense, or communication in relation to the crime committed. There has to be a direct link.
Like the example of a blind person who, feeling someone bump into them unexpectedly, assumes it's an attack and pushes back in perceived self-defense, causing the other person to fall and get injured. Their blindness directly affected their perception and reaction.
Exactly. The defect contributed to the commission of the offense or limited their ability to avoid it.
And illness? How is that different from the exempting circumstance of insanity?
That's the crucial distinction. An illness is mitigating if it diminishes the exercise of the offender's willpower, but does not completely deprive them of consciousness of their acts or understanding of right and wrong. Insanity, remember, is a complete deprivation of intelligence reason that's exempting. Illness here is a lesser impairment. It affects their ability to control their actions fully, but doesn't negate voluntariness entirely.
So, maybe someone suffering from severe clinical depression or anxiety commits a crime, and while they understood what they were doing was wrong, their illness significantly impaired their judgment or ability to resist impulses.
Precisely. The illness reduced their willpower or cognitive function related to the crime, but didn't reach the level of legal insanity. It warrants mitigation, not full exemption.
And finally, under mitigating circumstances, there's a catch-all: analogous circumstances. What does that cover?
This is Article 13, Paragraph 10 of the Revised Penal Code. It's a flexibility clause. It allows the courts to consider other circumstances that are similar in nature and effect to the specific ones listed, 1 to 9, even if they don't fit perfectly into any category. The court looks for a situation that reflects a similar diminution of intent, intelligence, or freedom of action.
Like the example sometimes cited, extreme poverty leading someone to steal food might be seen as analogous to an incomplete state of necessity. Or perhaps being over 60 with significantly failing eyesight could be considered analogous to the over 70 seniority rule.
Yes, those are potential examples. It gives the court discretion to achieve fairness when the specific letter of the law doesn't quite capture a situation that clearly involves reduced culpability.
Okay, we've covered justifying, exempting, and mitigating. Now for the flip side, aggravating circumstances. These are present, the sources say, when the crime or the way it was committed reveals a greater perversity, a greater criminality and dangerousness in the offender. Factors that make the act worse in the eyes of the law.
Precisely. Their presence serves to increase the imposable penalty, moving it towards the maximum end of the range prescribed by law for that specific crime. However, it's absolutely crucial to remember this point. No matter how many aggravating circumstances are proven, the court cannot impose a penalty beyond the maximum penalty legally defined for that crime. There's a statutory ceiling. Aggravating circumstances push the penalty within that range or sometimes dictate the maximum, but never exceed it.
Our sources list several different kinds of aggravating circumstances. Can you walk us through the main types and what makes them different?
Certainly. The classification helps understand their effect. First, generic aggravating circumstances. These can generally apply to most crimes, unless they are inherent in the crime itself. Examples include taking advantage of public position, dwelling, nighttime, recidivism, being a repeat offender. Second, specific aggravating circumstances. These apply only to particular crimes specified by law. Treachery, alevosía for instance, is specific to crimes against persons. Cruelty is another. Third, inherent aggravating circumstances. These are circumstances that are already considered integral elements of the crime itself. Therefore, they cannot be used again to increase the penalty. For example, evident premeditation is inherent in robbery, so it doesn't aggravate robbery further. Abuse of confidence might be inherent in qualified theft. Fourth, special aggravating circumstances. These are specified by law to have a particular effect, often mandating the imposition of the maximum penalty, regardless of mitigating circumstances. Examples include committing a crime while under the influence of dangerous drugs, if proven, or quasi-recidivism, committing a felony after having been convicted of another crime before serving sentence or while serving it. And finally, qualifying aggravating circumstances. These are the most serious. They don't just increase the penalty for the existing crime, they actually change the nature of the crime itself, upgrading it to a more serious offense with a higher penalty range altogether.
So, if a circumstance is qualifying, it's not just adding a bit more punishment to, say, homicide. It actually transforms the crime into something else, like murder.
Exactly. That's the classic example. Treachery or evident premeditation, if proven in a killing, doesn't just make homicide worse, it qualifies the killing as murder, which carries a much heavier penalty, reclusion perpetuate to death versus reclusion temporal for homicide. Similarly, using violence against or intimidation of persons qualifies theft into robbery.
And a critical procedural point for the court to consider any of these aggravating circumstances, generic, specific, qualifying, they must be specifically alleged in the formal complaint or information filed by the prosecution, right?
Yeah.
And then proven.
Absolutely crucial. Unlike justifying, exempting, or mitigating circumstances, which are usually defenses raised and proven by the accused, aggravating circumstances must be explicitly stated in the charging documents and proven beyond reasonable doubt by the prosecution during the trial, just like the elements of the crime itself. Due process demands the accused knows exactly what factors are being used to potentially increase their sentence.
Okay, let's look at a few compelling examples of aggravating circumstances listed under Article 14, taking advantage of public office.
Yes, this is both generic and can sometimes be special. The key question is, did the accused abuse their public office or use the influence, prestige, or facilities of their position to commit the crime? If they could have committed the crime just as easily without being in that office, then this circumstance doesn't apply. They must have actively used their position to facilitate the crime, like a police officer using their badge to gain entry to commit robbery.
How about dwelling, Murata, committing the crime in the victim's home?
Yes, this is a generic circumstance. It applies when the crime is committed in the dwelling of the offended party. It's about the disrespect shown for the sanctity and peace of another's home. It doesn't necessarily mean the offender broke in. Even if they were invited in but then committed the crime there, dwelling can apply. The focus is on the victim being attacked in their place of refuge. However, it's generally not aggravating if the victim gave sufficient provocation for the crime originating from the dwelling, or if the offender and victim live in the same dwelling.
What about nighttime nocturnidad, uninhabited place, despoblado, or by a band, quadrilla?
These are generic, and sometimes considered together if they concur. Nighttime is aggravating only if the darkness was specifically sought by the offender to facilitate the crime or to ensure impunity. Escape. It's not just that the crime happened at night. Uninhabited place means the location was chosen because it offered no reasonable possibility of help or detection. Again, it must be sought out for that purpose. By a band requires more than 3 armed malefactors acting together in the commission of the crime. The armed part is essential, and they must act as a group.
Evident premeditation. Premeditation homicida. This sounds like planning.
It is, but it requires more than just prior intent. The prosecution must prove 3 things. 1, the time when the offender determined or decided to commit the crime. 2, an act manifestly indicating that the offender clung to that determination. They didn't waver. And 3, a sufficient lapse of time between the determination and the execution, allowing the offender to reflect upon the consequences and for their conscience to potentially overcome the resolution. It needs clear external evidence of planning and reflection, not just suspicion.
We mentioned alevosía, treachery, as qualifying. Can you define it again?
Certainly. It's a specific and often qualifying circumstance for crimes against persons, like homicide, physical injuries. It exists when the offender commits any of these crimes employing means, methods, or forms in the execution thereof which tend directly and specially to ensure its execution without risk to himself arising from the defense which the offended party might make.
So it's about deliberately making sure the victim has absolutely no chance to fight back or even retaliate. Utter helplessness.
Exactly.
Yeah.
A sudden, unexpected attack on an unarmed person from behind is a classic example, or attacking someone while they are asleep or defenseless. The core is the conscious adoption of means to eliminate any possibility of defense.
And cruelty, ensañamiento, making the victim suffer more.
Yes, this is a specific circumstance. It applies when the offender deliberately and inhumanly augments the suffering of the victim by causing other wrongs not necessary for the commission of the crime. It's not just about inflicting multiple wounds. It requires proof that the offender enjoyed or delighted in making their victim suffer slowly and gradually, inflicting unnecessary physical or moral pain beyond what was needed to actually commit the crime, e.g., kill them. Importantly, for cruelty to apply, the victim must generally still be alive when the cruel acts intended to prolong suffering are inflicted.
Beyond Article 14, our sources mention other special aggravating circumstances, like being part of an organized or syndicated crime group.
Yes, this reflects modern concerns. If a crime is committed for financial gain by an organized or syndicated group defined as 2 or more collaborating for gain, or under specific laws like Dangerous Drugs Act, 3 or more conspiring for certain offenses, the law often mandates the maximum penalty.
And things like use of explosives, loose firearms, dangerous drugs, or even use of a computer system.
Correct. Specific laws have introduced these as special aggravating circumstances for various offenses, often resulting in significantly higher penalties. It shows the law adapting to evolving threats and methods of crime commission.
Okay, now for a really intriguing category, alternative circumstances. These can swing either way. They might be aggravating or they might be mitigating, depending on the specific facts. Like a legal chameleon, you said.
Indeed. They are unique in that their effect isn't fixed. The law recognizes that these factors can cut both ways. Our sources list three main ones: relationship, intoxication, and degree of instruction and education. Their effect, whether they worsen or lessen the crime, depends entirely on the nature of the crime itself, its effects, and the other conditions surrounding its commission.
Let's start with relationship. So the fact that the offender and victim are related, spouse, parent, child, sibling, etc., how can that be both good and bad for the offender?
It's highly context dependent. Relationship can sometimes be exempting, as we saw in specific property crimes between close relatives, like simple theft between spouses, or in the rare case of killing a spouse caught in the act of adultery, Article 247, death under exceptional circumstances. It can be mitigating, for instance, in less serious physical injuries inflicted on a relative of a lower degree, like a parent disciplining a child, though this is very restricted now, or potentially in some property crimes not covered by exemption. But more commonly, relationship is aggravating, especially in crimes against persons like homicide or serious physical injuries, if the victim is an ascendant, descendant, or sibling, same level or higher degree relative. The violation of trust and natural respect makes the crime worse.
And always aggravating in crimes against chastity.
Yes, the sources state it's always aggravating in crimes against chastity, like rape or acts of lasciviousness, due to the profound abuse of trust and vulnerability inherent in those situations within a family context. So a relationship is a very dynamic factor, constantly evaluated against the nature of the crime.
What about intoxication? Being drunk or under the influence of drugs. How can that be both mitigating and aggravating?
Okay, intoxication is mitigating if two conditions are met. One, the offender committed the felony while intoxicated, and two, the intoxication was not habitual. They aren't a habitual drunkard or drug user, and it was not subsequent to the plan to commit the felony. They didn't get drunk in order to commit the crime.
So if someone isn't normally a heavy drinker, has a few too many unexpectedly, loses inhibitions, and commits a crime they wouldn't normally commit, that could be mitigating because their willpower was diminished.
Exactly. The law recognizes the temporary impairment of judgment.
But what if they are a habitual drunkard, or they deliberately drank to get liquid courage before carrying out a planned crime?
Then it flips. Intoxication becomes aggravating. Habitual intoxication suggests a general disregard for societal norms, and intentionally getting intoxicated to facilitate a crime shows greater perversity and planning. The law generally presumes intoxication is non-habitual or unintentional unless the prosecution proves otherwise.
And the last alternative circumstance, degree of instruction and education. How does a person's level of schooling affect their liability?
Generally, a low degree of instruction and education, or illiteracy, is considered mitigating. The rationale is that such individuals may lack the full capacity to understand the nature and consequences of their actions, or the nuances of the law. It suggests a lesser degree of malice or understanding.
But it can also be aggravating. When?
Yes, it becomes aggravating when an offender has a high degree of instruction and education, and they specifically take advantage of or abuse their learning or skills in order to commit the crime.
Like a highly educated chemist using their knowledge to manufacture illegal drugs, or a sophisticated accountant using their skills to commit complex fraud.
Precisely. In those cases, their education isn't mitigating. It's an aggravating factor because they deliberately misuse their advanced knowledge to perpetrate the crime, showing greater cunning and culpability.
Okay, we've covered a lot of ground. Just one category left. Absolutory causes. These sound fascinating because, as you mentioned, a crime is actually committed. The act is defined as criminal. But for specific reasons, usually public policy or sentiment, no penalty is imposed.
That's exactly right. This is where the law effectively says, yes, technically a crime occurred here, but we are choosing not to punish it. Okay. They are distinct from justifying circumstances where the act was lawful and exempting circumstances where voluntariness was absent. Here, the act is wrongful, and the actor is technically culpable, but the law absolves them from punishment nonetheless. It really begs the question, why would the law do this? Why define something as a crime but then not punish it?
It seems counterintuitive, like the legal system saying, technically, yes, you broke the rule, but practically, considering everything, we're letting it go.
Exactly. It often reflects societal values, practical considerations, or aims to avoid results that would seem unjust or disproportionate. Let's look at some examples from our sources. Spontaneous desistance. If someone starts to commit a felony, but voluntarily stops themselves before completing all the acts of execution and before causing the intended harm, the law encourages people to back away from crime.
So if someone breaks a window to commit burglary, but then immediately changes their mind and runs away before taking anything?
Yes, that could be spontaneous desistance from the intended burglary. Another is punishing only consummated light felonies. Attempts or frustrations of light felonies, very minor offenses, are generally not punished unless they are against persons or property. The law doesn't want to clutter the system with very minor, incomplete offenses. Certain accessories to a crime are also absolved if they are close relatives of the principal offender, like a spouse, parent, child, sibling, provided they didn't personally profit from the crime. This recognizes family loyalty, however misplaced.
Ah, like hiding your sibling after they committed a crime out of family obligation.
Potentially, yes, as long as you didn't benefit. We also saw this under relationship. Theft, swindling, estafa, or malicious mischief committed between certain close relatives, spouses, descendants, siblings living together, are generally absolved from criminal prosecution. Public policy prefers not to criminalize these internal family property disputes. Then there's mistake of fact. This is where the person acts wrongly, but under a completely mistaken understanding of the facts. So if the facts had been as they believed them to be, their act would have been lawful. There's no criminal intent.
Like genuinely picking up the wrong identical suitcase at the airport baggage claim, truly believing it's yours. You committed the act of taking another's property, but without any intent to steal.
Exactly. The mistake negates the criminal intent. And finally, instigation versus entrapment. Instigation is an absolutory cause. This is where law enforcement officers or someone acting for them actively induce or lure someone into committing a crime that they otherwise would not have committed. The idea originates from the instigator, not the accused.
So the police basically plant the criminal idea in someone's head and push them towards it.
Yes, that's instigation, and it absolves the accused. This is contrasted with entrapment, which is not an absolutory cause. Entrapment is where officers merely provide an opportunity for someone already predisposed and intending to commit a crime to actually do so. They set a trap for someone already planning criminal activity. That's considered a valid law enforcement tactic.
Wow. What a truly deep dive into the intricate landscape of criminal liability. It's absolutely clear now. From acts that are completely justified and lawful to those that are excused due to lack of voluntariness. Total factors that lessen a penalty or significantly increase it, and even those rare situations where a crime technically happens but no punishment follows. It's undeniable that the law is far, far more nuanced than a simple guilty or not guilty verdict.
Indeed. Understanding these circumstances, justifying, exempting, mitigating, aggravating, alternative, and absolutory, reveals the incredibly intricate balancing act the legal system attempts. It's constantly weighing accountability, deterrence, public safety, and individual fairness, all while trying to consider the complex web of factors surrounding human action, intent, emotion, and external pressures. It truly underscores that context, intent, and the specific surrounding facts are absolutely everything when assessing criminal acts and assigning liability.
So, what does this all mean for you, the listener? It means every detail matters. Every nuance of intention, every external factor, every element of the situation can drastically alter the course of justice. It really challenges us, doesn't it? To look beyond the surface headlines of an alleged crime and consider all the deeper currents, the legal principles, the human factors at play. We sincerely hope this deep dive has given you a fresh, more informed perspective on the law and what truly goes into determining criminal liability. Next time you hear about a legal case unfolding, perhaps in the news or a documentary, you might find yourself thinking, I wonder which of these circumstances were argued. Was there unlawful aggression? Was discernment a factor? Did treachery qualify the crime? Was there maybe an absolutory cause involved? Ugh. It adds a whole new layer of understanding. Until our next deep dive, keep digging, keep questioning, and keep learning.